My fellow Americans, today, we confront a defining moment in the ongoing relationship between the executive branch and the constitutional limits placed upon it. On June 2, the Trump administration, seeking to reshape the federal government on a scale not seen in decades, made an emergency appeal to the highest court in the land. The administration has asked the Supreme Court to intervene, urging it to remove a federal judge's order that currently prevents the sweeping layoffs and restructuring efforts they seek to implement. The Department of Justice, representing the administration, argued passionately that the president should not be restrained by a requirement to seek congressional approval for executive branch staffing decisions. In their view, this order by a lower court rests on what they describe as an indefensible premise, that the President of the United States must seek permission from Congress to manage the human resources and structural design of the executive agencies under his control. But the rule of law, and the Constitution that frames our democracy, stands as the ultimate authority. U.S. District Judge Susan Illston, presiding in San Francisco, found reason to believe that this initiative by the administration violates both legal precedent and constitutional principle. She responded to a lawsuit brought by unions, nonprofit organizations, and municipalities who claimed that the president's restructuring plan was not only unlawful but would also cause irreversible harm to essential public services. Judge Illston's ruling did more than pause a policy, it reflected a commitment to preserving the functional capability of our government. She pointed out that after drastic reductions in staff, many federal agencies would no longer be able to fulfill the mandates Congress has lawfully assigned to them. Her decision to halt the layoffs and agency reorganizations across 22 federal agencies was not taken lightly. It was a recognition of both the scope and the risk of the administration's plan. The administration quickly appealed, bringing their arguments to the Ninth U.S. Circuit Court of Appeals. But on May 30, a three-judge panel in San Francisco denied their request, ruling 2-1 against the administration's attempt to override Judge Illston's order. In a sharply worded opinion, Judge William Fletcher, joined by Judge Lucy Koh, both appointed by Democratic presidents, wrote that the president's executive order far exceeds the supervisory powers granted to the executive branch by the Constitution. This is not merely a bureaucratic struggle. It is a battle over balance, accountability, and the very foundations of American governance. The Constitution is clear: while the president holds the power to oversee the executive branch, that power is not without limits. Separation of powers remains one of the bedrocks of our republic, and attempts to centralize authority without the consent of Congress are antithetical to that principle. What the Trump administration proposes is not just reorganization, it is dismantling. Tens of thousands of federal workers could lose their livelihoods. Government programs and services relied upon by millions of Americans would vanish overnight. And all of this, the administration argues, can and should happen without a single vote in Congress. But the judiciary has so far stood as a bulwark against this encroachment. It has reminded us that unilateral decisions by the executive must conform to the law, and that sweeping changes to the federal government demand more than a signature. They demand oversight, collaboration, and legitimacy. At stake are not only jobs and institutions, but trust. Trust in the idea that no president, regardless of party, can override the will of Congress with the stroke of a pen. Trust in the checks and balances that keep power from becoming tyranny. And trust in the belief that the courts will uphold the rights of the people, even in the face of executive pressure. The president has argued that the ability to manage the executive branch should come with the ability to reduce its size at will. But history, and law, say otherwise. Every reorganization of consequence, from the creation of Homeland Security to the restructuring of the military, has gone through Congress. The president does not stand above this process, he stands within it. Opponents of the administration's plan are not just defending existing jobs, they are defending democratic governance. They recognize that this kind of sweeping authority, if unchecked, could set a dangerous precedent. One administration could decide to gut regulatory bodies. Another might cripple agencies that provide healthcare or environmental protection. And none would need to answer to the legislative branch. That is not how this democracy was designed to function. The American people did not vest all authority in a single person, no matter how forceful their personality or popular their campaign. The Constitution divides power for a reason: to prevent overreach, to ensure debate, and to protect freedom. Today's emergency request to the Supreme Court is therefore not just a legal filing, it is a test of our system. It is a question of whether the courts will defend the separation of powers or allow it to be bypassed in the name of efficiency or ideology. It is a moment that calls for judicial courage and constitutional clarity. The plaintiffs in this case, unions, nonprofits, municipalities, represent the real-world effects of these proposed changes. They see communities that would lose vital support. They see employees who have dedicated their lives to public service now facing sudden unemployment. And they see a federal government reshaped not by consensus, but by command. Let us be clear, reform is not inherently wrong. Governments must adapt. Bureaucracies should be evaluated. But that process must be lawful. It must involve those elected to represent the people. It cannot be imposed by fiat. This debate will continue, and the Supreme Court now holds the power to decide. Will they stand with the Constitution and the careful balance it demands? Or will they endorse an unprecedented expansion of presidential authority? Whatever the outcome, this moment reminds us of the importance of civic vigilance, of informed citizens, of an engaged judiciary, and of a Congress that must not relinquish its role, even in the face of executive ambition. This is not about politics, it is about principle. It is about ensuring that the power to govern remains with the people, expressed through their elected representatives, protected by an impartial judiciary, and restrained by a constitution that has endured through war, depression, scandal, and division. The stakes are high. The precedent set here will echo across administrations and generations. Let us hope the court sees not